You're watching Behind the Headlines. I'm Pacchia. It's known as the Revolving Door, the hiring of personnel back and forth between the public and private spheres in a given industry. For those calling for more stringent regulation of our financial sector, the nexus between government service and private enterprise is a problem that precludes meaningful oversight. Others say it's not only unavoidable, but it actually ensures that workers bring highly relevant experience to their respective jobs. Joining me now to walk through the issue, I'm happy to say we have the man known as the Sheriff of Wall Street, former governor and attorney general for the state of New York, Eliot Spitzer. Welcome, sir. Thanks for stopping by.
Pleasure to be here.
The topic has a lot of people angry. Just by way of example, when Lanny Breuer left Department of Justice a couple months ago to go work for law firm Covington & Burling for, I think, the third time in his career, a lot of people were angry at the perception that he was going to defend Wall Street firms after a tenure in government that was seen as too light on those firms in the financial crime space. That anger aside, is the revolving door actually a problem that needs to be fixed with respect to financial regulatory reform?
Look, on the smallest of the issues you just raised, I agree with how you characterize Lanny's tenure as head of the criminal division at Justice. Many very poor decisions, and like Lanny as a guy, I just think it was a disaster.
It's the first time I've ever seen a major law firm actually protested. Occupy Wall Street had numerous members of their organization arrested at the doors of a law firm. I'm used to seeing big corporations and investment banks protested. Never a law firm. This really has people angry.
There is an anger. Look, when it comes to the revolving door, I think it is a better metaphor than diagnosis. And by that, what I mean is the imagery of it is perfect. People who revolving back and forth, as you say, the private sector into the regulatory agency that oversees the very sector where they had clients, where they were operating and charging enormous fees, and then back again the moment they leave their tenure. Here's why I'm not one of those who says you must, once you are active at a regulatory agency, never go back to that sector, and once you've been active as a lawyer in a sector or non-lawyer, likewise, ever be in a position to regulate the sector. I think there are some examples where the revolving door has been an enormous problem. I think that you can look at some of the former SEC chairs and say that they came from the defense bar, and then when they got there, they had internalized the defenses they had articulated for so long and failed to understand that they had a new responsibility, and therefore they did bring with them the baggage of having been representatives of the agency and could not separate intellectually and emotionally their past from their new tenure. On the other hand, we have examples of people like Gary Gensler, who went from Goldman to the CFTC, and I think virtually everybody would agree he's been tough, he's been smart, he's been vigorous. And so there are examples that run in either direction. Mary Jo White, we still don't know which way it will cut. If she doesn't live up to the expectations people have, they'll say, aha, the revolving door. So I rephrase the problem this way. Can people separate emotionally and intellectually one job from the past job? Do they have the internal integrity? That's a very hard thing to do, to say, when I was an attorney representing these guys, I made every plausible argument, but now I'm here as a prosecutor or as a regulator, and therefore I have to view it through a different prism and remove the hat. If people, so it's a question of the person's capacity to understand the difference in the job. It is not as simplistic as saying, aha, you were there in the past, therefore you can't come over to this side.
But that said, still, is there anything that can be done in terms of a regulatory fix to at least move away from this perception?
Sure. And by the way, people, you were kind to say Sheriff of Wall Street and all that, which was, it's always still nice to hear, I suppose. I represented some of those guys when I was in private practice before I was Attorney General. Nobody's screaming revolving door, Spitzer should. So again, one more little data point. Are there things we can do? Of course. There can be longer time periods where one cannot go from a regulatory agency back to represent clients in individual cases. There should be an absolute bar on that if the case was before the agency, or a 2-year ban on a sector, or longer. You can create all sorts of buffers, and that would give the public the comfort that both the reality and the appearance of lack of independence are being addressed. And so buffers is the easiest way. Outright bans and bars are talked about. And the idea of having a permanent regulatory staff is what some people propose. I think that would be to diminish the creativity and understanding of some of what we need in the regulatory structure.
At the end of the day, this is all about money, of course. And when you see people in government, judges, administrators, regulators, oftentimes they make fractions of what their private sector counterparts make.
But they're a lot happier. I got to get my pitch in for government service, and it's not. I'm not being facetious. I think, look, I've often thought there's sometimes, not always, but sometimes an inverse correlation between what we pay people and how much fun the job is.
Right.
But I say that as having been a lawyer, being paid a fair bit, and saying, God, this is terrible. Anyway.
Right. That said, would paying government employees more across the board go a long way towards solving this problem?
It would depend what order of magnitude. In other words, I don't think we're ever going to get to the point where we will pay SEC lawyers what private sector partners are being paid. And so there's always going to be an imbalance there. And as long as there's an imbalance.
But as that imbalance grows, at some point should some protective measures be taken? I mean, how much is Mary Jo White making this year compared to the people that she ultimately has to regulate?
I don't know with precision. Let's posit
it's an ocean of difference, right?
Absolutely. Let's say she earns a bit under $200,000 as chair of the SEC. It's not wildly one way or the other. And she was making several millions of dollars as a partner, one of the senior partners at Debevoise. Yes, that's a yawning gap. And so there are many consequences of that, none of which are helpful for government. But it is true. I think the lawyers in government tend to be happier and derive their joy and satisfaction not from the size of the paycheck, but from, theoretically, the existential joy of what they're doing.
I think part of the reason
doesn't pay rent, but it's,
sure.
but it's there.
to be sure. I think part of the reason this is so topical now is that there's this pervasive dissatisfaction with DOJ for not prosecuting the banks for misconduct related to the foreclosure crisis. You were a very active prosecutor of bad behavior on Wall Street during your time. What do you make of your successors across government?
I'm disappointed, and I try very hard not to personalize this, but I think there has been almost a formalization of the too big to fail, being too big to manage, being too big to prosecute, being too big even to regulate in a meaningful way. And I think Attorney General Holder, in his comments not long ago, that the economic impact of bringing a criminal case, or sometimes even a civil case against some of these companies, weighs heavily in his consciousness, was the most formal admission that too big to fail may be too big to prosecute, to which the remedy to me would be, okay, break them up.
Yeah.
Or at least have that conversation.
Right.
Think about or figure out how you can mitigate the ripple effects, the corollary harm that flows from a prosecution. I think there's been this overstated fear of prosecution that is pegged to the Lehman bankruptcy. People say, you indict, you will drive into bankruptcy, Lehman, boom, the world fell apart, which I think misunderstands both the economics and the legal structures involved. But put that aside, there's been a hesitancy that in HSBC, money laundering may be the easiest example, just because, at least to the extent the facts are known, it was rather egregious. And yet there really were not criminal sanctions of any reality.
It feels like, and I might be wrong, but it feels like it's an extremely unusual part of American history where we have broad swaths of the economy that is outside the effective jurisdiction of the federal government. Is this the new normal, and do you see this situation continuing into the future, or do you think it's more of a temporary blip in our
I hope it's temporary.
history?
I hope it's temporary because I don't think it serves justice well. I don't think it serves the public well. And I think it is better if we have confidence, as we need to have confidence, that the Justice Department will, in fact, have oversight, be comfortable taking the appropriate aggressive decisions that are needed to ensure integrity in the system. Well, we paid the price in 2008 for the failure to be sufficiently rigorous in looking at things that we knew that were bad. Excess leverage, playing with other people's money, embracing too big to fail, knowing securitization of bad debt, all these things, some criminal, some civil wrongs, some not wrong, just bad judgment. Obviously, all three converged, but nonetheless, the deregulatory spasm contributed and was the major causal factor in leading up to 2008. So the consequences of this are very real.
I want to talk to you about some recent comments by SEC Commissioner Mary Jo White. In her previous life, of course, she was a longtime defender of Wall Street firms, working for a major law firm. She said recently that her agency will require admissions of wrongdoing in some cases of malfeasance, but not all.
Right.
What do you make of that statement?
Well, look, some obviously is a somewhat elastic term. No, I would the notion of settlements where the bad actor neither admits nor denies has become something we've debated about more vigorously recently. It's a debate we should have. I am of the view now that if the government brings a case, extracts a civil penalty, money, or injunctive relief, there should be an admission that they did something wrong. Otherwise, it becomes merely a business transaction where you are calibrating and balancing the cost of litigation, risk of victory. I'll give you some money. We all go home. And you don't send into the economy a meaningful statement about changing behavior. If the objective of these cases is to change behavior, then admitting the behavior is wrong would seem to be an essential part of it. And I just think that somebody's going to say, well, wait a minute, Spitzer, when you were Attorney General, you had settlements which were neither admit nor deny. I did. I now look back and think, you know what? I'm not so glad we did that. I'm not so happy with it. And certainly, given the recidivism rate that we're seeing in recent years, where the same actors over and over continue to do bad things, suggesting, I don't want to say necessitating, but suggesting that the cost of settlement is simply rolled into the business model, we got to change it and break that cycle somehow. And so saying, look, you want to settle, you got to admit what you did was wrong. That has collateral consequences in terms of other litigation. So maybe you get a little less money for the government, you reserve a little bit for private litigation, but we have the statement to society, yes, that act was not proper.
Mr. Spitzer, before I let you go, want to get your thoughts on the upcoming mayoral elections in New York City.
We have one.
Who do you like?
I don't want to talk about like or dislike. I think if this were the Kentucky Derby, I think there would be 4 horses that are got candidates. I know them all. They're going to take offense at this. They're not horses, but there are 4 of them whom I think are serious contenders. I think John Liu has a harder time. On the Democrat, I think a Democrat will win. Mike's capacity to hold on for 12 years notwithstanding, I think now this year, barring something unforeseen, a Democrat is likely to win. Joe Lhota, interesting, good candidate, but I think he has a hard time. So of the 5 Democratic candidates, I think John Liu is the laggard right now, has a hard time breaking through to make it to a runoff. If you think that nobody will break 40% of the other 4, any combination of 2 could theoretically make it into the runoff. I think Billy Thompson, perhaps structurally in the best position to assure himself a seat in the runoff and move on.
That's right. He picked up the endorsement of the teachers union earlier today.
He did. Which there are always debates about how much that matters. But in a fractured race, some of those larger unions do carry some sway.
Every little bit helps. Mr. Spitzer, thanks so much for your time today.
Thank you for inviting me.
If you'd like to learn more about the cases and issues we just discussed, be sure to check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Eliot Pacchia. Thanks for watching.